Good evening to all of you. Even though more than 6 years have lapsed since the department issued showcase notice to Vodafone, the saga has not come to an end, and the debate and the litigation is still continuing. And in fact, not only Vodafone, there are some cases involving the very same points like Vodafone still pending in the Supreme Court, and we do not know whether the ghost is going to get resurrected. The structure involved in Vodafone, there is an entire business deal, was quite complex. Even though the facts involved therein was rather, I think, straightforward and simple, lawyers in fact have a unique technique in making cases very complex. The simple fact in Vodafone was that Hutchinson SR was admittedly carrying on the business of telecom in India, having been granted a telecom license, and had also established infrastructure, had put up several mobile towers, and had its own brand which was well established in India. And it decided one day that it should actually divest its business interests in India. Mind that it was not merely a divestment, not a divestment of merely an equity interest. It was a divestment of its business in India, and for that purpose, it actually proceeded to call for a global tender, clearly telling the world that it is seeking to quit India and it wants to divest its business interests in India. And it made a global offer, and the global offer was responded to by both foreign companies as well as Indian companies. In fact, SR was its joint venture partner. It sought to actually raise a red flag, saying that it had a preemptive right of purchase. Apart from that aspect, the companies actually which wanted to actually participate in the global tender included not only Vodafone, but also companies like Reliance, which showed keen interest to actually make a bid for acquiring the 67% stake which was put up for sale. Hinduja also showed its interest. And ultimately actually Vodafone became the successful bidder. Then thereafter what happened was, when Vodafone became the successful bidder, of course this was preceded by various correspondence term sheets and also agreements between the parties. The Income Tax Department swung into action, issued a show cause notice. The show cause notice was challenged before the Bombay High Court, which I would call as the very first round. And the main ground of challenge was that the very show cause notice lacked jurisdiction, in as much as the transaction was not liable to be taxed in India, and that it involved only share transfer, and there was no transfer of any capital asset situated in India. And various other issues were raised before the Bombay High Court in the first round. The Bombay High Court actually, in the first round, prima facie actually found that there was some substance in the case of the department, and in fact dismissed the writ petition filed by Vodafone by finding that Vodafone had suppressed some vital documents. But before that, I would like to point out that a very interesting thing happened when the writ petition was actually taken up for hearing. And I think I'll just put the first slide, no? I think you have that. So, the judge actually put a question that was the dog running in the Indian territory or was it running in a foreign territory? And actually the dog itself, it's proclaimed in the advertisement that Hutch is now Vodafone. So the brand name in India was changed from Hutch to Vodafone. And I argued that from this advertisement itself, you can actually view from a common man's point of view, there is a common perception test, was that there is a close nexus, there is a sort of an income which is generated in India by reason of the brand change, a succession which takes place in India, and several provisions of the Income Tax Act do get attracted, including the definition of capital asset, transfer, etc. I'll come to all that. And this, coupled with the various transactional documents, was fit enough to dismiss the writ petition challenging the show cause notice. And therefore, and the share purchase agreement, which was foundational to decide upon the jurisdiction of the taxing authorities, was not placed before the Bombay High Court. And that was the reason which actually played a very important role in the minds of the Bombay High Court to dismiss. Thereafterwards, the matter came before the Supreme Court, but before that, to actually make you aware, the core questions involved before the courts were whether the transfer of controlling interest in Hutchinson SR Limited resulted in accrual of income to Hutch, directly or indirectly, within the meaning of Section 9 of the Income Tax Act, thereby obliging Vodafone to deduct tax on the transaction. That is actually Section 9, according to us, is of a very wide amplitude. According to the department, there was an accrual of income in an indirect manner. It was a transfer within the meaning of Section 9. The argument of Vodafone was it only involved the transaction involved, whether the transaction involved the transfer of a single share of a company in Cayman Islands, or whether it involved a transfer of diverse rights and entitlements constituting capital assets situated in India. This is the alternative, the department's case. As Alok was pointing out, the total tax liability, including penalty and interest, was rupees 12,000 crores, which was the highest demand at that point of time. All the crucial facts have till now so far not been placed correctly before the public. There has been a hue and cry as though the tax department has been going against the blood of foreign investors. And even the Supreme Court, with great respect in this particular case, I think went off on a tangent. Like the judgment of the National Judicial Accountable Commission, this judgment, I think, in tax jurisprudence, I think is one of the greatest blunders of the Supreme Court.